in exclusion of his heir. Eleemosynary corporations are chiefly hospitals or colleges in the university. These were all of them considered by the popish clergy as of mere ecclesiastical jurisdiction. However, the law of the land judged otherwise, and with regard to hospitals, it has long been held that if a hospital be spiritual, the bishop shall visit, but if lay, the patron. This right of lay patrons was indeed abridged by statute 2 Henry V c. 1, which ordained that the ordinary should visit all hospitals founded by subjects, though the king's right was reserved to visit by his commissioners such as were of royal foundation. But the subject's right was in part restored by statute 14 Elizabeth c. 5, which directs the bishop to visit such hospitals only where no visitor is appointed by the founders thereof, and all the hospitals founded by virtue of the statute 39 Elizabeth c. 5 are to be visited by such persons as shall be nominated by the respective founders. But still, if the founder appoints nobody, the bishop of the diocese must visit. Colleges in the universities, whatever the common law may now or might formerly judge, were certainly considered by the popish clergy, under whose direction they were, as ecclesiastical, or at least clerical corporations, and therefore the right of visitation was claimed by the ordinary of the diocese. This is evident because in many of our most ancient colleges, where the founder had a mind to subject them to a visitor of his own nomination, he obtained for that purpose a papal bull to exempt them from the jurisdiction of the ordinary, several of which are still preserved in the archives of the respective societies. And I have reason to believe that in one of our colleges, wherein the bishop of that diocese in which Oxford was formerly comprised has immemorially exercised visitorial authority, there is no special visitor appointed by the college statutes, so that the bishop's interposition can be ascribed to nothing else but his supposed title as ordinary to visit this among other ecclesiastical foundations. And it is not impossible that the number of colleges in Cambridge, which are visited by the Bishop of Ely, may in part be derived from the same original. But whatever might be formerly the opinion of the clergy, it is now held as an established common law that colleges are lay corporations, though sometimes totally composed of ecclesiastical persons, and that the right of visitation does not arise from any principles of the canon law, but of necessity was created by the common law. And yet the power and jurisdiction of visitors in colleges was left so much in the dark at common law that the whole doctrine was very unsettled till King William's time, in the 6th year of whose reign the famous case of Phillips and Bury happened. In this the main question was, whether the sentence of the Bishop of Exeter, who, as visitor, had deprived Dr. Bury, the rector of Exeter College, could be examined and redressed by the Court of King's Bench. And the 3 puisne judges were of opinion that it might be reviewed, for that the visitor's jurisdiction could not exclude the common law, and accordingly judgment was given at that court. But the Lord Chief Justice, Holt, was of a contrary opinion, and held that by the common law the office of visitor is to judge according to the statutes of the college, and to expel and deprive upon just occasions, and to hear all appeals of course, and that from him and him only the party grieved ought to have redress, the founder having reposed in him so entire a confidence that he will administer justice impartially, that his determinations are final, and examinable in no other court whatsoever. And upon this, a writ of error being brought in the House of Lords, they reversed the judgment of the Court of King's Bench, and concurred in Sir John Holt's opinion. And to this leading case all subsequent determinations have been conformable. But where the visitor is under a temporary disability, there the Court of King's Bench will interpose, to prevent a defect of justice. Thus the Bishop of Chester is visitor of Manchester College, but happening also to be warden, the court held that his power was suspended during the union of those offices, and therefore issued a peremptory mandamus to him, as warden, to admit a person entitled to a chaplainship. Also, it is said that if a founder of an eleemosynary foundation appoints a visitor and limits his jurisdiction by rules and statutes, if the visitor in his sentence exceeds those rules, an action lies against him, but it is otherwise where he mistakes in a thing within his power. 4. We come now in the last place to consider how corporations may be dissolved. Any particular member may be disenfranchised, or lose his place in the corporation, by acting contrary to the laws of the society, or the laws of the land, or he may resign it by his own voluntary act. But the body politic may also itself be dissolved in several ways, which dissolution is the civil death of the corporation, and in this case their lands and tenements shall revert to the person, or his heirs, who granted them to the corporation. For the law doth annex a condition to every such grant, that if the corporation be dissolved, the grantor shall have the lands again, because the cause of the grant faileth. The grant is indeed only during the life of the corporation, which may endure for ever. But, when that life is determined by the dissolution of the body politic, the grantor takes it back by reversion, as in the case of every other grant for life. And hence it appears how injurious, as well to private as public rights, those statutes were, which vested in King Henry VIII, instead of the heirs of the founder, the lands of the dissolved monasteries. The debts of a corporation, either to or from it, are totally extinguished by its dissolution, so that the members thereof cannot recover, or be charged with them in their natural capacities, agreeable to that maxim of the civil law, si quid universitate debitur, singulis non debitur, nec quod debet universitas, singuli debent. A corporation may be dissolved, 1. By Act of Parliament, which is boundless in its operations; 2. By the natural death of all its members in case of an aggregate corporation; 3. By surrender of its franchises into the hands of the king, which is a kind of suicide; 4. By forfeiture of its charter, through negligence or abuse of its franchises, in which case the law judges that the body politic has broken the condition upon which it was incorporated, and thereupon the incorporation is void. And the regular course is to bring a writ of quo warranto, to inquire by what warrant the members now exercise their corporate power, having forfeited it by such and such proceedings. The exertion of this act of law for the purposes of the state, in the reigns of King Charles and King James II, particularly by seizing the charter of the city of London, gave great and just offence, though perhaps, in strictness of law, the proceedings were sufficiently regular. But now it is enacted that the charter of the city of London shall never more be forfeited for any cause whatsoever. And because the common law corporations were dissolved, in case the mayor or head officer was not duly elected on the day appointed in the charter or established by prescription, it is now provided that for the future no corporation shall be dissolved upon that account, and ample directions are given for appointing a new officer, in case there be no election, or a void one, made upon the charter or prescriptive day.